There are a few situations where you may abate or exempt a tax without a timely filed application by the taxpayer. The first is where the tax is completely invalid. For example, an individual who does not own a parcel of real property or any taxable personal property is not subject to tax on that property. In addition, some exemptions, like the exemptions for charitable and religious organizations, are complete exemptions. For example, no tax at all is owed by a religious organization on its house of worship. If a tax is altogether void, the taxpayer can sit back and not pay the tax. Then, the taxpayer can raise the invalidity of the tax as a defense if the collector brings a contract action to collect the tax. Or the taxpayer can raise the invalidity of a tax title foreclosure action brought by the treasurer. The taxpayer can also decide to pay the tax under protest and then file suit against the collector to recover the full amount paid with interest. If the taxpayer prevails, you can abate the tax as required to comply with the court's decision. The second situation relates to uncollectible personal property taxes where the taxpayer is dead, is insolvent, or has disappeared. The collector gives notice to the assessors, who have 30 days to process the abatement. You may conduct a due diligence inquiry to find out the reasons for the abatement, but the collector decides that the taxes are uncollectible. There is also a procedure under General Laws Chapter 58, Section 8, that lets assessors apply to the Commissioner of Revenue for authority to abate a tax when they do not have jurisdiction to act because the taxpayer did not file an application on or before the application deadline. Under this procedure, the Commissioner can revive your jurisdiction to abate where you can demonstrate that the taxpayer is seriously harmed or eligible for a full or partial exemption. It is important to recognize that the 8 of 58 application process is not a taxpayer right. Taxpayers' rights to contest their assessments and obtain reductions are terminated by missing the abatement application deadline. 8 of 58 is a discretionary administrative procedure that you must initiate by application and may use to clear uncollectible taxes or rectify significant assessment errors. You are not required to request abatement authority for any particular taxpayer. DOR is not required to grant it, and you are not required to exercise it if granted. Assessors may request that a taxpayer who has filed an abatement application allow them to inspect the property and provide under oath written information reasonably required to determine its fair cash value. The taxpayer must respond to the information request within 30 days. A taxpayer who fails to comply with your information request loses the right of appeal unless the taxpayer can demonstrate a good faith reason for not complying. A taxpayer who did not respond to your pre-assessment request for written information may also lose the right to appeal. Assessors have 3 months, not 90 days, from the date they receive a taxpayer abatement application to grant or deny an abatement. The 3-month action period can be extended by written consent of the taxpayer. The application is deemed denied if you do not act within the 3-month or extended action period. For this example, a taxpayer files an application with you on February 1st. The application is deemed denied on May 1st if you do not act on the application by that date. You must notify the taxpayer in writing of their disposition of the application. If you grant an abatement, you give notice by issuing an abatement certificate to the taxpayer. You also give notice of the abatement to the collector and accounting officer so that adjustments may be made to the commitment and overlay. If the application is denied or deemed denied, you must issue a denial notice. Abatement certificates and denial notices must be sent within 10 days of the date the assessors act on the application or the application is deemed denied. The date of the assessor's action or the deemed denial starts the clock running on the taxpayer's right of appeal to the Appellate Tax Board. However, if you do not send the taxpayer the required notice within 10 days of the action or deemed denial date, the taxpayer gets an additional 2 months to file through a process known as petition for late entry. You must retain a book or record of all abatements granted. For each abatement granted, The record must list the name of the assessed owner, the fiscal year of the tax, the amount assessed, the amount abated, the date the abatement was granted, and the reason for the abatement. If the abatement was granted to put into effect a statutory exemption, the abatement book must also list the statute provision under which the exemption was granted. The abatement book is public record and is open to mandatory disclosure under the Public Records Law. Abatement and exemption applications and supporting documentation submitted by taxpayers to your office are confidential records that may only be inspected by you and your staff, Department of Revenue staff, and state and local officials and private auditors in the performance of their official or contractual duties. Likewise, material and documents submitted in response to your discovery requests are confidential. For example, income and expense information relevant to determining the value of a business might give a competitor an unfair advantage if subject to public disclosure under the Public Records Law. Accordingly, these materials are not available to the public. Let's review what we've learned in this lesson. There are a few very limited situations where you can abate a tax, even though a taxpayer did not timely file. As we learned earlier, if a taxpayer does not file an abatement application on or before the application deadline, you cannot act on the application. The exceptions to this strict filing requirement are when the collector determines personal property taxes are uncollectible for certain reasons. The Commissioner of Revenue authorizes you to abate under General Laws, Chapter 58, Section 8, and the taxpayer does not owe any tax for the year and wins in an action to collect the tax or to recover the tax after paying it under protest. Once a taxpayer files an abatement application, you can require the taxpayer to allow you to inspect the property or provide you with information you need to determine the fair cash valuation. As a general rule, a taxpayer who does not comply with these requests cannot get an abatement. You have 3 months from the date the application was filed to act on it. If you do not act on it within that time, it is denied by law. You must also send the taxpayer a notice within 10 days of the date you grant or deny the application, or the date the application is deemed denied. Although applications are confidential, you must maintain a record of all abatements and exemptions granted, and that record is open for public inspection.